Okay, I'm sorry for that little hiccup. So we are now live streaming. I will read the ethics conflict statement. Members of the committee are hereby advised of their duty under the State Government Ethics Act to avoid conflicts of interest and are instructed to refrain from participating in any matter coming before this committee with respect to which there is a conflict of interest. Does anybody believe they have a conflict of interest? Nope. Okay, so with that, let me just give a quick rundown of this opinion. I'll just give a very brief summary, and then I'll open it up, and Jay, you take over, and we can start our meeting. This proposed opinion rules that each office in a multi-county public defender district may be treated as a separate law firm and may handle conflict cases involving co-defendants or parties with adverse interests under certain conditions. So we received this inquiry from one of our counselors, Mr. Kemp, who is in a multi-county district and wanted the ethics committee to look at whether or not we can treat each public defender's office in a separate county, albeit part of the same judicial district, as separate law firms for purposes of running conflicts. And the reason that he was requesting that is because in some counties, in some districts, there are not enough lawyers on the court appointed list to take these conflict cases, or lawyers out in practice who are not on the appointed list to take on these conflict cases. So the opinion provides that we will treat each county as its own separate law firm, provided that they have their own staff. They can screen for confidentiality purposes and making sure that each office operates independently and that they don't have access to the other office's client information, and that preserves confidentiality. So this was presented at the January meeting, and we had a subcommittee assigned to discuss this issue. Fran Muse, who was on our subcommittee, had some comments about it. Ellen Murphy, who was also on the subcommittee, had some comments, and so I'll let them just explain what their concerns were. But the main thing is about whether or not screening really is an option or an available, and can we preserve confidential client information?
Thank you, Nicole. For those of y'all who don't know me, I'm Jay Vanoy, and I got the pleasure of being the chairman of this subcommittee. So, welcome. Thank you all for being here. So I think we can just approach this informally and everybody speak their mind and give us their comments. What I'd like to do, I guess, to start is maybe open the floor up to our guests, who obviously are situated in these offices. Probably means they have, I'm assuming, opinions on it that I certainly would like to hear. So, um, Jacob, you or Seth want to start and give us your thoughts on this opinion?
Um, I'll start. I'm new to this. I've been a criminal defense lawyer for 20 years, but I'm new to being the chief public defender or any public defender. But I've done a lot of appointed work. What I found in my office is that I do carry a caseload, but I probably have 25% of what the other lawyers in my office have. So I do a lot of consulting because I've got a lot of experience with handling serious cases and all cases, but I could see it running into a situation where if you had one of my Alexander County lawyers and one of my Iredell County lawyers, and they're going at odds, um, I can't talk to any of them about the case, obviously, and that could be not that I can add any, great wisdom or knowledge. They're certainly capable, but that's just the first thing that came to my mind. And if you, oftentimes, we have to talk to clients, and we have to talk to difficult clients, and we have to talk to clients who are facing years and years and years in prison. And I have been called into some of those conversations on plea negotiations or matters that are in a trial posture. And what do you say to that client who knows or who asks you, well, does the other person work for you too? Or my co-defendant, that lawyer works for you too? Or you sitting in and talking to them and you just have to say no? It's just an issue that would have to be dealt with. I guess fundamentally it would be the appearance of impropriety that you would have to deal with and talk to the client about.
Thank you, Seth. Jacob, you want to chime in? Do you have any comments on it?
Sure. Not having any conflict attorneys is a huge issue. So my district is Brunswick County, which is more affluent, has more attorneys. I've got a court-appointed list. Columbus is more rural. There are attorneys and attorneys that step in and help me. Bladen is a legal desert. There are lists that I don't have any attorneys on, and I have to beg, borrow, and steal when it comes time to farm out a conflict. And sometimes there are no attorneys, and I have been fortunate so far in that the Columbus bar has stepped up, the Brunswick bar has stepped up and driven to Bladen County to help. It is a huge issue. I also recognize that it's a huge issue. I don't carry a huge caseload because running the district is an enormous job. And my attorneys do talk to me. If this rule were to be permitted, there are going to be issues because they all report to me directly. So that is an issue. I do know that the AG's office, I think, has some exception where they can screen and be treated separately. Their divisions are treated separately. It's a lot larger than what Seth and I are working with. There's a lot more broken down parts. So I do have some concern that this could appear to be inappropriate. Even if you guys approve the rule, I will tell you that I would use it sparingly because it does make me nervous. So I don't know that I'm advocating one way or the other, to be honest with you. I do recognize that there are enormous issues in indigent defense right now. We're not paying attorneys enough. We can't get enough attorneys on the list. But I also recognize that altering this rule could cause public loss of faith in the indigent defense, and I don't want that. So long story short, I'm going to get by one way or the other. I will beg attorneys to continue to do this. I will make it my job to beg attorneys to continue to do this. I won't rest until people have attorneys. And I respect whatever you guys decide.
Thank you, Jacob. We appreciate that input. How about let's open it up to the committee. Who wants to go first?
I had a question for Jacob. Everybody hear me okay?
Yes, sir.
Yeah,
Right.
got you.
Jacob, do you have a separately established staffed office in Bladen, your legal desert there?
I do. It's staff. Yes,
I do.
It's staff
Okay.
office in
All right.
Columbus, Brunswick.
And I guess, and we have a public defender's office in the second district. The second district's 5 counties, but they don't have separately staffed office. They have one office that covers and works for all 5 counties. So I think that this office really wouldn't be affected by that. But in reading the fact pattern, I was kind of like, if you got co-defendants in one county and you got, and I kind of feeding off what you said, Jacob, and Seth, this idea that if you've got what would appear to be conflicting interest, then you would then appear together if those cases were joined for trial, right? And that's the appearance we're worried about, right? And of course, and that assumes that they would be joined for trial. It may very well be that they wouldn't be joined for trial, but that's a whole nother legal analysis, so to speak. I think we're generally speaking about cases that would, or the potential of having them together on a trial or in court together at the same table, so to speak, or same side, and then dealing with that perception of, who's really working for who here. I mean, Lord knows, I know we both, the public defenders and the DA's office, we all get accused of working for each other anyway. So from that perspective, So yeah, I understand that. Okay, I just wanted to, because when I was reading the fact pattern, I was like, what's the likelihood of something like that happening, as opposed to the impact upon the rights of the accused, or and the perception of those realities that we deal with within the court system. Okay, thank you. I appreciate your input.
And I was also reading this fact pattern as more an opportunity, like I guess I'll just go with our district, mine and Jacobs, but if you've got a family that spills over the Bladen and Columbus County lines and you know, A stabs B in Bladen County, and then B's cousin retaliates in Columbus County. And so you've got a situation where the victim is the defendant in Columbus, but also the other victim is the defendant in Bladen, and they both have the PD's. They both have Mr. Jacob Ward as their lawyer. And that is, even though they would never technically appear at the same table, that's also just kind of one that I could see arising. And I also, I don't really know what the right answer is here, because I recognize there's a major issue and I don't want to do anything to keep our attorneys from being able to handle this. But I do worry, especially in rural areas, which ironically is where we need the lawyers the most, that's where that, oh, well, you can't trust them because they were working both sides of the of whatever. And so I just wanted to clarify, I guess, that I'm looking at it more as not only could they appear at the same table, but it could be that cross warrants or a fact pattern that spills over into separate incidents in separate counties, especially where there's counties where there's a lot of crossover. So I'm not sure if that's what the information was talking about, but that is kind of what I had in my mind when I was reading it.
Thank you, Tara. Fran, I saw your hand.
Hi. So I asked to serve on this subcommittee because I feel so strongly about this. I was that young public defender that Seth was talking about that relied on the leadership and mentorship in my office. We were an office of 4 lawyers at the time. We were very close. We talked about cases all the time. Those 3 lawyers were my mentors. They're still my mentors: James Williams, Bob Trinkle, Pat Devine. And, you know, for a young lawyer, any lawyer really, especially even a more experienced lawyer that's in the middle of a really, tough case with hard facts, to not be able to talk to the colleagues that they're closest with, the other public defenders in their office, I think it's just a huge issue for office morale. I think it would have a negative impact on these offices. These offices are generally small. I think these lawyers lean on each other. I think there's a huge appearance of impropriety here. It's not just in the courtroom, but family members, talking in the community, as Tara said, about, when my brother doesn't have a good lawyer, they're all working, for the same office, for the same state. They're all, in bed with the local DA. Public defenders already struggle with, an image issue. People don't think they're real lawyers. They don't think that they're true advocates. And I think putting a public defender in this situation is only going to, add to that and make it worse. I mean, I've had clients before when I was a public defender asking me, well, do you have a real law degree? I mean, that's the image that they're already fighting against. So, I recognize I did court-appointed work for many years after I left the public defender's office. I know it's a struggle for these rural counties. I get it. I just don't think this is the answer. One of the things noted in that opinion was that they would have to have, if we were to adopt this opinion, they would have to have distinct leadership. That's not going to happen. I mean, Seth is the leader in his office. Jacob is the leader. You might have different managing attorneys, but the leadership is the chief public defender. So there's no way for us to have distinct leadership.
Thank you, Fran. Yes, Seth, see your hand. Go ahead.
I wanted to follow up on Fran's comment and Tom's too. Tom painted the picture of these 2 lawyers sitting in the courtroom going at each other with co-defendants on opposite sides. I mean, that's a bad scenario, but I think even a worse scenario is that when one of those clients goes to prison for 20 years, this is going to be looked at. And just because there's an ethics opinion that says it's okay, that doesn't mean it's a good idea. And so the onus is going to be on these offices, with the limited resources that we have, and we're going to really have to make sure that that MAR holds up, or that our procedures rather hold up against that MAR, because that's coming. Anybody that goes to prison for a lengthy amount of time, they want to get back in court, and if they're unsatisfied with the outcome, they try to undo what was done. So I can see it being an additional workload for our offices, especially the smaller offices. But I'll also say I'm similarly situated to Jacob. I have a great PAC list. That may change over time, and it will certainly decrease over time. But for now, I have plenty of conflict lawyers in both counties. We're fortunate.
Tara, yeah, go ahead.
I also had a question. We're a new eCourts county, just happened in February. We were in the most recent rollout, so I'm not sure if y'all's counties have it yet. But I also wonder, with the case management software, which I think Jacob and I may have discussed separately, if there's even a way to block out the office. If the PD's office has access to the PD's cases, again, not that probably anyone would intentionally do that, but the appearance of that an attorney on the other side can access the notes, or I'm not sure how that software operates, but if there's not a way to block out certain attorneys, I feel like with this new software we're working with, that could also open a door for issues. I'm just not educated enough about it, because as a conflict counsel, I don't use the same software the actual PDs use, but just wanted to throw that out there as a potential issue to consider.
That is that is a huge issue. And if you are in the PD's office, you have access to attorney manager, you have access to everything in each file. And AOC does not have a way to block it off. And I've worked for the state for a long time. AOC is not going to develop a way to block it off because it'll cost a lot of money. But that is true.
Thanks, Tara. I met with Drina Baker, my public defender in my district, and also met with Glenn Gurney, the appellate defender. And that issue was raised about access to information. And Glenn echoed your concern about what happens on appeal. Is that going to be a possible issue about a potential conflict?
And I spoke with I'm Eddie Thomas. I'm with the Public Defender's Office in Charlotte, and I spoke with my chief PD this morning, Kevin Tully, and I know he raised the Odyssey issue as well, in terms of attorneys having access to that information, and really not this opinion not having an answer for that. Also, he raised, the same issues that everyone else has in terms of the appearance of impropriety, the idea that, we as public defenders, as everyone has noted, we have some difficult time with clients, especially, early on clients, they don't get to choose their court-appointed attorney. Someone is just appointed to them. And now, they're very distrustful of the system to begin with. They're distrustful of us, and the idea that you would have two attorneys from one office, technically one office representing two co-defendants, that's going to be a problem in trying to establish that attorney-client relationship moving forward. It can have a lot of consequences as a result.
Yeah, thank you, Eddie. My comment or one concern too, and Nicole, maybe you can guide us through this, but if you read RPC 65 and it says the public defender's office should be considered a single law firm, and I know this is a multi-county, but I'm not sure that's really a distinction with a difference. I mean, I think we're trying to create maybe an exception here with this rule by saying because it's multi-county, it's different. But we also have this RPC on the books from 1989, that to me, conflicts with this particular opinion we're talking about today, too. So I don't know if that throws another wrench in it, but that concerns me. And, you know, it's always been the case where, you know, law firms that have multiple offices can't do this. You know, private law firms can't do this. I know there's a separate ruling for the AG's office, and that seemed to focus on, it was the government, you know, and the government's big, and, you know, so the AG's office can do that. But had in addition to this concern about RPC 65, I, just for the record, have the same concerns all of y'all do that you've brought forward so far. I think while there's definitely a problem with indigent defense, and that's going to be an ongoing problem we have to deal with, I don't know that this is the solution. I think it could create more problems than it solves, for sure. Anybody else comment? Ellen, I know you got to say something, Ellen. Come on.
Do you want me to be quiet? I don't mind being quiet. Because I'm just here. First of all, I'm learning so much listening to y'all. I'm here because I nerd out in the conflicts rules, not because I understand how this works on the ground. But a couple things. My initial concern with this was compliance based on limited resources, which I think Seth addressed. I think, Jay, you add an additional concern, which is, okay, so we're saying multi-county, and that's how but really you could do this within Mecklenburg, within one office, right? It's artificially geographically breaking it up, right, into different firms, right? Okay, so there's that. And this is probably moot, but I'm going to say it in case it triggers someone to think about something that I can't think of right now, but I think there's a big difference in a public defender and an attorney general's office. I don't necessarily equate public defenders with government lawyers, because public defenders have individual clients. And I think government lawyers are lawyers, and the rules that govern government lawyers do so because they represent agencies and entities and the state, right? And these kinds of things. So to the extent that this opinion focuses on a public defender as a government lawyer, that troubles me. I know that would take some finesse, and Nicole was like, Ellen, I wish you would stop talking. But I do think there's a difference there. And I was also concerned with this opinion after rereading it, that there was no notice requirement to the clients if we did this. We require that of a private firm. So anyway, those are my rule thoughts.
I think there was some discussion about the client could consent to it. Again, I don't even like that discussion. I'm putting people in a situation where they've got to make a determination about, I can have a public defender within the same office, or, they can't find me a lawyer. I don't think we should pass that burden to the accused.
I agree with that.
I agree. And I feel like we all want to make PD's lives easier, and we may accidentally make it more difficult by adding these tasks of obtain consent, discuss this with them, don't talk about this within the office, but also worry about this software. Because even on the staff, like I know in our counties, Jacob's staff are pulling like triple duty, especially in our Bladen County. Do you have any designated staff for Bladen, Jacob?
No, so when the General Assembly set up my district, they expanded it at the last minute. So I have 4 legal assistants that run 16 attorneys across 3 counties.
Right. So even, I guess, just considering that when you look at a staff issue, then you kind of look at, okay, what staff is assigned, and are they accidentally working on 2 cases to have a conflict? And again, I think we all want to make PD's lives easier, and I understand the spirit of this request, but I just worry about the implications if we pass this of accidentally creating administrative tasks, and in addition to all the ethical issues we talked about.
Yeah, with my staffing, which the General Assembly I'm sure is going to fix, I'm not worried about it, but with my staffing, it would be next to impossible to separate it out.
Also, I will go back to the leadership thing, because it's only really one leader, and that is the chief PD, because ultimately everything falls upon that person. So you can try to create something where, there's some leadership in one county, and the chief PD is in the other county, and so things are a little bit different. But when a client complains and, maybe want a different attorney, maybe have some ethical complaints against an attorney, that generally lands on the doorstep of the chief PD to handle or make a decision about. And so I don't know if you can actually create a create distinct leadership for each county. If there's something that major happens at trial, and the trial judge wants to see, hey, I need to talk to your boss about this ethical violation or about what's going on here, then that means the boss for both of those co-defendants is going to be the chief PD coming in to speak on two employees that are opposite of each other in trial. And so I don't think you can actually do that.
I totally agree with that, and I think that most of the things we're discussing are very unlikely, but how often do we all see the craziest stuff? Or if you're in criminal defense, you're like, well, that would never happen, and then it happens. I mean, that happens to me at least once a week, and I don't do a lot of court-appointed work anymore. So I feel like we think of these things as like, well, that's really unlikely, but I feel like the second we do it, then the worst issue in the world is going to come up and force a scenario like that where so I appreciate bringing up these possibilities because it sounds like, oh, well, that probably wouldn't happen. But I mean, what if it did? So I really appreciate those comments.
Good
I
conversation.
think Tom has his hand up. Tom wants to say something.
Okay.
And I'll be honest with you guys. As a prosecutor, the last thing I want to see are public defenders put between a rock and a hard place because they work so hard at what they do and they do such a good job in what they do. And I understand that while they are part of a public defender's office, they are independent lawyers once they are assigned cases for the most part, and just like we are in some respects. And I think the goal of the inquiry, I think, is laudable, to figure out a way where we can provide legal services in those conflict situations. And I guess that kind of leads me to my question. Is there something where we haven't talked about that can, within the inquiry or even outside the inquiry, that would solve the solution? I know ultimately the solution is probably a legislative one. If we have public defenders in each district, that would allow public defenders to, kind of like what we do sometimes when we have a case that may be a conflict case, ask a public defender from another district to handle it. And that has happened. We're fortunate enough to be next to Pitt County, and I know they've helped each other out with those conflicts, but I know there's not enough public defenders offices across the state as of yet, and hopefully that'll change in the near future as well. But is there, I guess trying to think outside the box. And Ellen, I think some of the things you said were important enough to figure out how we can, if there's a way to establish a process to remedy the issue raised within the inquiry. And I don't know if there is, because I'm not familiar enough. I'm not a conflict nerd, as you claim to be, but I've dealt with enough conflict issues as a prosecutor in my time that I know it's not an easy thing to resolve sometimes. But I'm also sitting from the other side of the bar, so to speak. Anyway, are there other options out there other than let's report that, hey, legislature, this is a problem, and the only way you're going to solve this problem is by having public defenders in every district that will allow districts to lean on other district public defenders when those conflict cases arise, and assuming you don't have a PAC attorney available for those conflict cases.
I haven't done a 50-state survey, although it will be interesting to see. But I did talk to some colleagues, and Wisconsin addressed this similarly to what we are proposing, but they didn't do it through the government lawyer. They said this is much more like a traditional private lawyer. But they did come down on screening, and that it would work. And I don't know the details of that. I found their rule, but I'm happy if the committee, because I'm with you, Tom, I want to find a solution. If the committee wants me to see if the Nicole in Wisconsin would come and talk with us about why and how they got there, I'm happy to ask him. And there may be other states, and they may have talked to other states. I don't know.
Well, anybody else have any other comments? Want to say
Ellen,
anything?
I would find that helpful because I didn't find any other state's opinion. So if you could send that to me.
Yeah, it's really weird to find, Nicole. It's like they modified their 1.10 and they excluded public defenders from the definition of government lawyers.
Oh,
Mm-hmm.
That would be
I know.
that'd be a huge undertaking.
I know.
Opinion.
Would they?
Yeah.
But did they also then say that a public defender's office is not in itself like a law firm? Because I think, and knowing what I know about a public defender's office, the fact that in some respects you have your supervisor and public defenders talk about their cases back and forth, they are in some respects completely independent of each other as it relates to their representation of their clients. So they get to make decisions. For example, if I tell an assistant DA, hey, you're doing this for that case, my assistant DA has to do that. But if that public defender says, I'm going to represent my client in this way, even though the head PD says, I'm not sure that's the way you do it, they're not really beholden to that chief public defender in the manner in which they represent their clients. If I understand the intricacies of that law firm as it's defined, which is completely different than any other way a law firm is defined, like Jay mentioned in his comments.
Ellen,
I know that would be a heavy lift, Nicole. I know that would be a very significant lift from, as you're mentioning it, from the Wisconsin rule as well, to change that RPC 65 or whatever 65 that it's mentioned here.
I was just going to say, Ellen, if we do decide to go down that road of hearing from her, I would ask the committee that we identify all these concerns that we've raised about the appearance of impropriety, the access to information, all of this, the mentorship, and I want to hear from her. Did you talk about this? How are y'all addressing this? I don't know. That would make the discussion more meaningful to me if I knew that their committee had looked at all of these same issues that we all appear to agree on are issues for this proposed opinion.
So I guess what we need, Nicole, is a motion to keep this in subcommittee, rather than making a recommendation to the full ethics panel. Is we would keep
So
this.
I think you have two options.
Okay.
You can, one, ask Ellen to contact the Wisconsin Staff Council and ask that person to meet with us so we can keep it in subcommittee, and allow, hold another subcommittee meeting and then have the Wisconsin person participate. Second option is we don't think that we can issue an opinion and that we need to leave the rules the way that they are. A conflict is a conflict, and we don't issue an opinion that says, yes, we'll treat public defenders as two different offices, or we issue an opinion that says, no, this is not a possibility. In which case, I don't think we need an opinion that says no. Either we have an opinion that says yes, but this is how you do it, or we don't have an opinion.
Can I make a suggestion? I think Ellen's got a good idea, and so does Nicole, about contacting those folks in Wisconsin. I guess if you guys get that information and you say, there's no way in heck we're going to be able to, do this, or this won't fit our administrative settings or the processes we would have to go through to make these changes, then I think if you guys just report that back, there may not be a need to have that person from Wisconsin actually speak to us. But in the event that there is, and that may be relevant to maybe in some sense of the word, breathe life back into this process, then I think we can do that. But I think, and then if not, then I think Nicole's our response is, we're not changing anything about the rules at this point in time going forward.
So is that a motion to keep it in subcommittee, Tom? For now.
Yes, that's what's required. Yes, that's my motion. Thank you.
All right. There's a motion on the table to keep this in subcommittee. Is there a second?
Second.
Thank you, Ellen. There's a second. So is there any further discussion? All right, all in favor to keep it in subcommittee now and have Ellen reach out to Wisconsin, say aye or raise your hand. Any opposed? All right, that motion passes. We'll keep it in subcommittee because we may not be able to do this before the April State Bar meeting. So, it might just need to stay here and depending on scheduling, maybe we can pull it together and schedule another meeting here, before we meet in April, which would be great because then we could, do like Nicole says, we might be in a better position to make a recommendation to the ethics committee, or we may not. Or maybe that is, we're not going to issue an opinion, or that would be our recommendation, is not issue an opinion. So.
Right. So we can try to get that done. It just depends on what information Ellen can get out of Wisconsin, the timing on that. But if we can't have another subcommittee meeting before the April meeting, that's okay. I'll just put a memo and for the April meeting that it's in subcommittee and why, and that we don't have anything to present at the April meeting. So it's okay if we can't get it done before then.
Let me say one thing, Jay. So I just sent to Nicole the two things that I found. It would be helpful to me, Nicole, if you just look at that. It's just a court order and then like a bar article about what they did. And if you say this isn't happening, right? Like it is not, like North Carolina is not set up for this, then we'll stop it. If you think it is worth a conversation with Tim, let's you and I decide how that should work. And to be honest, because I am pretty green in terms of criminal conflicts, if you would be there with me, that would be great to help raise the concerns. Or you do it. I don't have to be involved, but I'm happy to, and we can go from there. Is that okay? Is that okay with you, Jay, Nicole?
Oh, that's certainly okay with me.
Okay, okay.
I'm sorry. I thought I was off mute. So yes,
Okay.
that would be okay with me.
Okay,
Yes.
thank you. Okay.
Yes. All right. Well, I think so. For now, we're going to keep it here in subcommittee. We're going to see what we hear back from Wisconsin and get Nicole's opinion based on what you sent her, Ellen. And, I think we'll probably have to reconvene whether we have the person from Wisconsin with us or not, so that we can, make a decision with or without that information as to what we as a subcommittee want to do. Whether that's before the April meeting or after, it doesn't sound like that's going to be a problem. So,
Okay. And Jay, I'll keep you in the loop as the chair. And then you can make a decision on whether we have another subcommittee meeting or not.
okay. That'd be great. Thank you, Nicole. Thank you all for participating. Thank you for being here. Seth, Jacob, appreciate y'all.
Yes,
your
thank you,
participation and your comments. Thank you very much. And
Thank y'all. Yeah, thank y'all for letting us join. It really means a lot to us since it's going to impact us. And I trust that you guys are going to do the right thing, and we'll go from there.
all right. And if we circle back and get with the Wisconsin people, we'll let you